Worship to the record, Masaba Raphael Gideon and Ikapuru Tumsimi.
Worship, this matter is coming up for mention. Requires worship about to be completed. We are praying for.
Mandatory bail. Your worship, the accused was charged before this court 23rd day of February 2024. And that's it is 2 months and 7 days, Your worship.
68 days?
67 days now. Your worship, I rely on the Constitution, Article 23(6)(b). Your worship, that person should be released on bail on such conditions as court considers reasonable. Your worship, I also further rely on the Constitutional Court authority. May please I will share a copy with the court. Your worship, this is the authority of Foundation for Human Rights Initiative versus the Attorney General, Constitutional Petition number 20 of 2006. And in particular, Your worship, at page 12, at page 12 of Your worship in particular, court agreed with Article 26(b), where Your worship, court rephrased what I read to court, and added that here the court has no discretion, it has to grant bail because of the use of the phrase "shall be released on bail" appearing herein. Your worship, in addition to the constitutional provision and the case law, the accused has sureties that would be free to present before court.
Your worship, the accused has presented 2 sureties for this court. And the first surety is she stays in Bombay cell. Bombay cell. Bombay cell Busamaga Westward, Industrial Division, Mbari City.
The accused person for mandatory bail Judge, we do appreciate the provisions of the same. However, we, just like any other bail application, Your Worship, in order to avoid proceeding by ambush, we seek an adjournment to verify the issue is presented because they are far away from the jurisdiction of this honorable court.
So yes, Chief Secretary is this court empowered under the provisions of Article 1, Article 23, 6B?
Yes, it is still. It is whether or not it is a discretion of this court.
I know, and that question, that article takes away the discretion of this court. It tells the court to impose conditions that are reasonable.
Thank you.
My view.
Yes, Your Worship, whereas that is very true. Court is obliged to impose those conditions depending on the circumstances. For example, if the sureties are within the jurisdiction and the authentic, court would impose different conditions from where the sureties are out of jurisdiction or they are fisheries. So this is something that we need to actually find out, Your Worship, and bring to your attention. And we believe, Your Worship, that with this, it will be easier for you to make an authentic, uninformed, and a reasoned ruling.
Chief Secretary, supposing the way the sureties are not substantial, what happens in the light of Article 26, 6B?
Yes, I understand.
Can I deny bail?
Your Worship, still, if prosecution is ready to proceed, you can deny bail. You see, the most important thing is court to make circumstantial directives that are not only intended to have the accused person return to court, but also to serve justice. Because this is a matter which is a bit complex, it's unusual. This is more of cyber, whose investigations can never be covered within the 2 months because of the so many technicalities involved. These are things Your Worship Court has to take into consideration. And it is our plea, Your Worship, that whereas court has the powers, we are asking as a prosecution that we be given time in the interest of justice to just verify, because it would also, court would also be taking a risk to consider a surety substantial, yet in actual sense, they are not substantial. So it is better, and it is actually better and safer to make a ruling knowing that the sureties are not substantial, but releasing the suspect on personal cognizance. And this is what we are speaking to, Your Worship. We would want to help court to make a reasoned judgment and to make a better precedent, because the sureties presented are totally different from the first sureties, and that explains a lot. Why has the applicant opted to produce different sureties from the ones he produced last time? That is an issue that comes to the back of this court, and this is what we want to help court with. And this cannot be done within hours. We need to verify, and this is you have had Budaka. Budaka is so many miles away from Kampala. We ask court, with all due respect, to just offer us this opportunity to also say that we are serving justice. We do appreciate the provision of the mandatory bail. We do appreciate. But we pray that we find out the authenticity of these sureties. Court could be handing the accused person to crocodile teeth.
Reply to Counsel Richard Dilibuka's submissions. Your Worship, in line with Article 23(6)(a. Your Worship, in line with Article 23(6)(b) of the Constitution, 23(6)(b) of the Republic of Uganda Constitution as amended, and case law by the Constitutional Court, Your Worship, that we availed to court, and my land friend, the State Attorney, has not made any reference to. It is stated that here the court has no discretion, it has to grant bail because of the use of the word shall be released on bail. Your Worship, here to make it mandatory that where trial has not started, court should release the accused on bail on the conditions that it will put in place. Your Worship, I remind the court that in early March, when we prayed for bail, our land colleague informed the court that the prosecution was ready to start with the case. It had enough evidence which was overwhelming, and we could immediately start prosecuting the accused person. Your Worship, up to date, we are only informed that investigations are still ongoing, and the 60 days, it is more than 7 days past the 60 days, Your Worship. And since this provision is states that it's mandatory, we pray that if state does not agree with the sureties, court rules on our prayer for mandatory bail in accordance with the law. Your Worship, state mentioned about the different sureties. We presented sureties to court for the comfort and confidence of the court that this person, in case of anything, there are people of responsibility that will ensure that he appears back in court. Your Worship, these sureties are all sisters to the mother of the accused. They are older.
I think Your Worship, yes, we don't do this one. This is a repetition of what I've submitted.
According to the Senior State Attorney emuwade, the state needs 2 weeks to open investigations. Counsel for the accused has applied for mandatory bail, citing Article 26(6)(b) of the Constitution of the Republic of Uganda as amended, and also the case of Foundation for Human Rights Initiative versus the Attorney General. He has presented 2 sureties, Moboya Lydia Kauri and Nabuzale Margaret Ann, both maternal aunties of the accused person. The state has sought an adjournment to verify the authenticity of the sureties presented to court, which the defense has objected to. Article 26(6)(b), Article 23(6)(b) of the Constitution of the Republic of Uganda is quoted in mandatory terms and it states, in the case of an offense which is tried by the High Court as well as by subordinate court, if that person has been on remand for 60 days before trial, then the person shall be released on bail on such conditions as the court considers reasonable. In the case of Foundation for Human Rights Initiative versus Attorney General, Constitutional Question number 20 of 2006, the Constitutional Court stated that under Article 23(6)(b), where an accused person has been incarcerated for 60 days before trial, final question by the High Court as well as the subordinate court, that person shall be released on bail on such conditions as the court considers reasonable. It went on to say that here the court has no discretion as to grant bail. I'm tied by the above constitutional provision and the above decision of the Constitutional Court. I am of the view that when an accused person has stopped the mandatory period on remand, court can always set bail conditions. It cannot adjourn the case for any other purpose, including investigation of sureties, because an accused person can be released on his own cognizance. In this case, the accused person, Musa Ibrahim, has got a mandatory period on remand, having been on remand for 60 days where the trial commencing, and hereby leaves him on bail on the following conditions as per Article 23, 6b of the Constitution. One is pay cash bail of 2 million. Each of these two sureties shall each execute a bond of 20 million, not cash. It deposits his national identity card in court, and is also given 2 weeks to deposit his passport in this court. It is not to mention the names of His Royal Highness, the Kabaka of Uganda, His Excellency Kaguta Museveni, Right Honorable Anita Among, and Honorable Nabosa Semugao, and any of his social media handles and who this case is heard and disposed of with, which is going to be cancelled. We had this matter on the 28th of May